On January 8, 1962, an envelope from Clarence Earl Gideon arrived at the Supreme Court of the United States. He asked the Supreme Court to review his case
on the grounds that I was made to stand trial without the aid of counsel.
In response, the Supreme Court decided to hear Gideon's case.
And with that decision, American history and the criminal justice system was forever changed. Welcome to Constitution Day 2013. Welcome to the Thomas F. Eagleton Federal Courthouse in downtown St. Louis, Missouri for today's program, Constitution Day 2013, the ongoing impact of Gideon versus Wainwright. Hi everybody, I'm Tim Gore, your host for HEC-TV Live, and I'm very happy to welcome you to the Judge William Webster courtroom here in the Thomas F. Eagleton Courthouse for the program today that HEC-TV is producing in collaboration with sponsorship from the Missouri Bar. We're going to look at what was an exceptionally important Supreme Court case that was decided 50 years ago this year, the impact of Gideon v. Wainwright and everybody's right to an attorney. To do so, we're going to be joined by an expert panel. We've got students here from various areas of St. Louis, and of course, as always, we look forward to your interactivity as well, whether you're watching on the web or TV, with your email questions. So don't forget, you can email us your questions to live@hectv.org. That's live@hectv.org. I look forward to hearing the ding on my phone so we can incorporate those into the program. We have some practical questions that came to us via email that I'd like to go through because I think some of us may have these same questions in mind. So first and foremost, if the accused chooses not to have a lawyer, is someone appointed anyway if they choose to defend themselves? How does that work, Bevy?
Well, an individual does have the right to represent himself or herself. And there's a line of cases where the courts have said that the trial judge, before they allow a person to represent themselves, has to show some understanding, first of all, of what it means to give up their right to counsel. So the court's going to conduct an inquiry of the accused to say, do you understand that by giving up your right to counsel, you're not going to have somebody there helping you with the questions. I'm not going to give you any special treatment because you represent yourself. So if you miss an objection, you miss an objection. Nobody's going to say, well, you're not a lawyer, you wouldn't know the difference. There have been cases where the court has said the trial court erred in not letting somebody represent themselves. They've also said it was a mistake to let somebody represent themselves because they weren't competent enough to handle their own case.
And Eric, the next practical question is, how is the lawyer chosen to represent the accused? Is there a pool of people and they get called up?
Well, in Missouri, we're fortunate to have the public defender system where we've got, for somebody who's indigent, we've got the right to an attorney. Now here's the rub sometimes, and that is, and Bevy's already mentioned it, who qualifies as indigent and who doesn't. And so that gets very complex. Here's the one thing we know for sure. You know, there's that old adage that he who represents himself has a fool for a client. That's usually true. Even if you're a very bright person, even if you understand what's happening, representing yourself is usually a bad decision because, as Bevy's already mentioned, it's just almost impossible to understand all of the things that a trained lawyer would know about how to protect a client in a criminal case.
Judge Weber, do non-citizens have the same right to an attorney that a citizen would have?
Absolutely.
It's anyone who goes through the legal system has the right to an attorney.
That's correct.
Now, are you able to get, I love the phrasing of this one, are you able to get a new lawyer after the case is started if you feel they aren't representing you well enough? How does that work? I mean, as a judge, are you monitoring the effectiveness of counsel? Do people come to you and say, this lawyer isn't cutting it, I need somebody else to represent me? What happens?
Well, that happens a lot. A person will be receiving the representation of one counsel and just doesn't like the way it's going. The lawyer representing she or he may be entirely acting in the most appropriate and professional way. The client just may not like the sound of the music, and so want someone else that will tell him or her something else. And so the judge then is in a position to decide, well, what is the basis for your request? And then the judge makes a decision as to whether or not to excuse counsel and appoint subsequent counsel. There are very definite standards what a judge considers in making that decision.
So those are some practical questions. We also had a question come about the impact on prosecutors. And Eric, I know you and I had some communication about this point before the program, so I wanted to make sure we brought this up. Basically, the question is, prosecutors, they want the defense guy to have a lawyer? Wouldn't it be easier to win a case if he didn't have one?
No, absolutely. You know, one of the misconceptions, again, about prosecutors is that we're out there just to get convictions at any cost. And that's not true. The ethical rules give prosecutors the duty not only to be advocates, but to be what the rules call a minister of justice, not simply that of an advocate. So we have the special obligation to make sure that defendants are accorded procedural justice. That's really important. That's why I'm always glad to have a good attorney on the other side.
Very good. So there's some practical things to deal with. Now, the court decided one thing, we need a counsel. But obviously the Sixth Amendment actually says effective counsel, and over time, since that point in time, the Supreme Court has continued to make other decisions dealing with what they mean by effective counsel and who exactly does counsel apply to. And we've gotten some advanced questions on 3 cases, and before we go to those questions, I just want the audience to be aware of the 3 cases we're talking about. The first of those is In re Galt, and Bevy, could you give us just a little blurb about what is In re Galt? It applies to juvenile offenders.
Right. It simply, I think, extends Gideon to juvenile people facing criminal charges.
And so that's a case that everybody should be familiar with. The second is Argersinger versus Hamlin, and this deals specifically with extending the right to state proceedings in different kinds of cases, Eric?
In misdemeanor cases, really any case where somebody could go to jail or prison for any significant period of time.
So this is the case where they say if there's a potential loss of liberty, you have the right to an attorney. Loss of liberty being jail time.
Exactly.
Okay. And then the third case we care about at this moment in time was known as Strickland v. Washington. And this one, Judge Weber, gets into effective assistance, correct?
That's correct.
Do they actually define effective assistance in this decision, or just do they say it has to be effective?
It has to be effective. And then there are some standards to determine, for a judge to determine whether or not it was effective. Justice Sandra Day O'Connor wrote the opinion, and she states in the beginning.
Hold that thought just a minute, because I know that's what this young man wants to talk about. You're going to get into it beautifully. Right. Go for it. Go for it, Kevin.
Regarding the Strickland v. Washington case, what constitutes effective counsel, and was the Missouri Public Defender's Office created before the ruling in order to serve the same purpose?
So let's first of all talk about the decision of what the court believed is effective counsel, and then we'll let Bevy talk a little bit about the second half.
Good. She said that this was the first time that the court had an opportunity to decide effectiveness, that they had decided whether counsel should be appointed. And she pointed out in her decision that, one, first there are 2 components. First, defendant must show counsel's performance was deficient, that counsel made errors so serious that counsel was not functioning as the counsel guaranteed by guaranteed the defendant by the Sixth Amendment, and 2, the defendant was prejudiced. This requires showing that counsel's errors were so serious as to deprive defendant of a fair trial, a trial whose result is unreliable unless a defendant makes both showings. So it's a pretty high standard, but those are the standards.
And Bevy, let's go to the second part of his question about the purpose of the Public Defender's Office. Did it exist prior to Gideon? Did it come in as a result of Gideon? Has it morphed over time, so to speak?
Yes, it's morphed. I think what Judge Weber describes pre-Gideon was any lawyer who showed up in court would get appointed to represent an indigent defendant. That lawyer might have been a tax lawyer or a real estate lawyer, and they didn't necessarily have the training that lawyers who do criminal work would have. So the public defender system originally started in the mid-1980s, and it became a little more structured late in the 1980s, and we are clearly now a state-funded system with one centralized office that monitors the performance of lawyers, the training of lawyers, our caseloads, our promotions, our hiring practices are all centralized. So we've grown sort of with Gideon to make sure that we're meeting the standards of Gideon and of Strickland.
Let's go to some more questions that deal with beyond Gideon, and we're going to go back to Verona, New York for a couple of questions now. So Verona, take it away.
How did the Gideon decision influence future similar cases, expanding or limiting the rights of the accused, including the recent federal court decision declaring New York City's stop and frisk laws unconstitutional?
Thanks, Verona. We'll take that one and then I'll come back to you. How do you think the Gideon decision has influenced future cases? They specifically referenced the recent New York decision about the stop and frisk, what the police were doing in New York City. Eric, in a general sense, how do you think it's made a difference?
There's no question that Gideon is one of those really important cases that focuses on defendants' rights. And we see the extension of those in, for example, this recent stop and frisk case. Now, that case is not yet over. We'll see what happens. That's a district court decision. It's certainly going to be appealed to the Court of Appeals, and my guess is there's a decent chance that ultimately our United States Supreme Court will make the ultimate decision as to whether that practice is legal or not. But there's no question that Gideon and the entire Warren Court was a court that was deeply interested in the rights of defendants, and fortunately that trend continues in our government, because there's nothing worse than having a criminal defendant, even if they're guilty, be stripped of their constitutional rights.
Very good. Verona, I'm going to come back to you for your follow-up question. Take it away.
Protecting the rights of the indigent, could the courts recognize socioeconomic profiling?
Socioeconomic profiling, is that possible that the courts could recognize that? This gets us into some of those things you were talking earlier, Bevy, about what makes an indigent person indigent. What's your response to that?
And I didn't hear the question completely. Is it whether
the courts could potentially recognize socioeconomic profiling?
Well, I suspect they can, and they may do it in an indirect way. They may, I mean, a lot of times the outcome of opinions may state one particular reason, but behind the scenes the court may have said, well, we were really sensitive to the rights of this poor person or this immigrant or some other issue in the case. So I don't rule out that they would consider that. I don't know how forward they would be about acknowledging it.
Now, Judge Weber, when does all this get to start for someone?
Very early. You know, in the early case of Powell, this involved two young men involved with a rape, interracial rape, and the case was indicted, tried, and everything in all three trials in 6 days. Now the process is slowed, because at the very earliest stages, a defendant is advised that of her or his right to speak to a lawyer, and in the Miranda case, it specifies the questions that the officer must ask before interrogating a defendant.
Okay. And the case you reference in terms of Powell, is my history right? That's the famous Scottsboro boys case? And that some people may be aware of in certain ways?
Yes. Yes, it was, three young men were accused of rape on a train, and they were classified as ignorant, without the means, very young, and all of that happened under very hostile circumstances. The court describes the period leading up to their trial. They were convicted by a jury. All three of them tried in one day, and all convicted, and were convicted and sentenced to death.
So a great many things have changed in the criminal justice system since that moment in time. I think we'd all be glad of that. And things continue to change because Gideon has impacts. We're talking now continually about the amount of public defenders we can have, how we can afford public defenders, how the lack of public defenders may or may not make the court docket too crowded, whether it forces some people to plea bargain. There's all sorts of perceptions, perhaps misperceptions, points of view, and we want to spend the last part of our program talking about that and looking at it from all sorts of different perspectives. And to lead us into that conversation, we've got Bailey with her question.
The current perception among many people is that the public defender's office is understaffed and overworked. And even though the public defenders are under obligation to represent their assigned clients to the best of their ability, many defendants still feel as if they are forced or encouraged to take a plea deal rather than have their day in court. How accurate is this perception, and what steps are being taken to ensure the public defender can adequately represent their client?
Bevy, I'll let you begin, and then we'll have the prosecutor end in this instance.
Thanks. I think that's a fair perception, and we're foolish if we don't realize that many people feel that way. Lawyers are, first of all, ethically bound to only handle those cases which they're able to handle. When I was a brand new lawyer, if you gave me a death penalty case and said, go to court and represent this person, I would have to refuse to take that case because that would be beyond my abilities. Same thing for a new lawyer who might be assigned 200 or 250 cases at a given time. How could you possibly handle all of those cases and give good representation, Strickland level representation, to every one of those accused people? Our job is to figure out how to manage that. And that's been the source of a lot of litigation. Do we represent every person? Do we now go back to the appointed system and essentially draft private lawyers into representing some of our indigent clients? Mr. Zahn will talk about other proposals to essentially privatize chunks of the public defender system. And I have some thoughts on that if we get to that point. And I think a lot of times clients do feel pushed through the mill. We have so little time. You'll meet your client, you'll read the police reports, you tell them what the recommendation is, and you make your recommendation to them. And a lot of times clients do just want to get it over with. Some clients want to have a trial, and they look at the lawyer sitting across the table from them, and they think, well, this person couldn't possibly get my case ready. Their phone's ringing off the hook, they're carrying 30 files into the jail, and that's where I think the big problem exists now.
Eric, yours a response to that perception question?
There's no question about this. The entire criminal justice system faces tremendous funding challenges. That's true of prosecutors, that's true of courts, that's true of police, that's true of crime labs. It's also true of public defenders. All of government is being asked right now to do more with less. Now, the special challenge we have with respect to public defenders' offices is we've got this constitutional right not only to counsel, but to effective assistance of counsel. And we've got to be sure that that right is upheld. So Bevy's right that there's been a lot of discussion of that. The good news is this. I work with public defenders every day in my job. And I believe in Missouri that the public defenders do a tremendous job for their clients. They're good attorneys who provide their clients very effective representation, which is a good thing.
Yeah, I think there might be some perception among some people that they've chosen to be a public defender. They're taking less money. They could make if they're really a good lawyer, then they could make a lot more money if they were at X law firm or something. And you're saying that's just, in
my opinion, absolutely untrue. There are great attorneys who decide that they want to give their lives to public service and do it as public defenders. I've know a number of them, Bevy being just one of many, who do this great job on behalf of clients that some people might not want to representing some very bad people who undoubtedly have done bad things, but making sure that they have their day in court.
Very good. Maureen's going to take us a little further down this road with her next question.
If in the state of Missouri, private attorneys are contracted to provide Sixth Amendment services to defendants who cannot afford other legal counsel, and because of the number of caseloads these attorneys may be burdened with as a result, can it be guaranteed to the defendant that his or her right to effective counsel and a speedy trial will be fulfilled?
And Judge Weber, I'm going to let you bring in the whole speedy trial implication into it as well, because we do have a right to a speedy trial also. How does this play into this whole concern we have about the amount of bodies going through the system?
Sure. Well, we, like Eric mentioned, are also in the federal system affected by what's going on with spending. For example, we have no criminal cases on Fridays because public defenders in the federal system are being furloughed, and deputy marshals are facing furlough. And so it is causing a definite problem. We have what is called a Speedy Trial Act in the federal system where from first appearance, I see Judge Noce back there in the background, he may scream if I get this wrong, but that from 70 days after first appearance, the case goes to trial. And many times that's extended because of various reasons. The defendant himself or herself may want the case extended because it may involve a lot of wiretap information and so forth. It takes a lot of time. But there is that rule, and if a person insists on going to trial, then they're going to get a trial in this court within the 70 days. And so when we are forced to have no trials and no criminal proceedings on Fridays, it is a real problem, and it's becoming more and more of a problem. And in many states, probation departments are being cut. They haven't planned well. We have in this court, but not all states have, and they're losing 20–30% of their staff. So it's an enormous problem. But I can echo everything Bevy and Eric said about the quality of lawyers representing individuals. The public defender system, the federal public defender system, is a wonderful system. I would, if facing trial, I would go there first, personally.
Well, it's kind of like, do you go to a heart surgeon who's performed a lot of heart operations, or do you go to the heart surgeon who hasn't done very many at all? Do I go to a lawyer who's defended a lot of people in similar cases or not? I mean, I would think on a regular basis, these are the people who are living the law over and over again.
They live it and they breathe it, and they die every time things do not go well. It's to watch them work is a great experience as a judge.
Bevy, you mentioned the possibility of us talking about future solutions, and that's a question that Kyle's going to lead us into as we talk about some alternatives.
According to the National Center for State Courts, 80 to 90% of all people charged with criminal offenses qualify for indignant defense. One of the main concerns for most people is that the cost of maintaining defense lawyers is extremely high, and people are concerned that criminal defense lawyers have a much larger caseload, which was proven true in a New York Times investigation, which showed that the average criminal defense lawyer had twice as many cases annually than the national standard. My question to you is, how could we fix this problem, and what alternatives could be used in exchange for the current system that we currently have?
Let's start talking future. What are some options? Bevy, I'll let you talk, and then we'll go to Eric.
Obviously, funding, adequate funding of all aspects of the criminal justice system is the key. And unfortunately, representing poor people accused of crimes is never high on the list of legislators, because their constituents don't want their money spent representing poor guilty people. So funding is, of course, the most important. We've gotten sort of creative, though, in everybody needs more money. Everybody wants more resources. So what's a way to reduce our caseload? Well, we could decriminalize some cases so that if jail time is not a possibility in a case, then that person is not entitled to a lawyer. If you aren't going to go to jail, you don't get a lawyer. So we've started looking at some lower level crimes, misdemeanors, small amounts of marijuana possession, paraphernalia possession cases, and asked the legislature to consider changing the punishment for those offenses so that we don't stack a bunch of lawyers with clients who really realistically aren't even going to go to jail. And then we can focus on the cases where people are facing jail time.
Eric?
You know, there's a similar possibility out there, which is to reserve state-paid public defenders for the most serious crimes, rapes, murders, assaults, and then contract out misdemeanor cases, maybe some low-level felonies, to private attorneys who might be able to do the job and might be able to do it for less, perhaps not. We used to do that in the state of Missouri some. The federal courts have a hybrid system where they use federally paid public defenders for some cases and then also contract out other cases to private attorneys. So that's a system that might work as well.
And Judge Weber, from your perspective, thoughts about future revisions to the system?
Well, I think the system Eric mentions is the most logical system. The law is what it is. Indigent defendants charged with criminal offenses are going to receive legal assistance from someone. If they're, let's take this situation where there's no money, and they're still going to receive representations from someone, and the bar is going to step up in some fashion and provide. It's a difficult situation, but it will be resolved in some fashion. Probably more funding, probably a hybrid system, perhaps change of the law. All of those things are being considered, and some combination of them likely will result in what it takes to effectively represent people who cannot afford lawyers. That will happen one way or the other.
Let's begin to summarize a little bit. Eric, if there was something that wasn't said so far today and I were to give you 30 seconds of time to say it in, what is it that students really need to understand about Gideon or the process of what we're talking about today that you'd like to leave them with?
Here's what I'd say, is that the Gideon case is an example of why, in my opinion, the United States Constitution is such a vibrant and important document. It's the greatest system, in this case, of criminal justice, in my view, on the face of the earth. And the Gideon case is just one example of how we continue to effectuate those rights to give justice not only for victims of crime, but also to see that defendants are also accorded their constitutional rights.
Thanks very much. Bevy?
I'm proud every day to represent people who are accused of crimes and to give teeth and weight to the United States and the Missouri Constitution. Frequently, I'll have people ask me, how can I defend those people? And I say, how can I not? It's my obligation as a citizen, as a lawyer, to stand up and give voice to those without a voice. I hear people say, well, they shouldn't have rights if they're guilty, and yet those are the same people who call me when they get a speeding ticket. And they want every right afforded to them and every privilege that might be within the system for that. And yet some people will question whether those same rights should be afforded to folks facing more serious charges. And I believe those rights should be enforced equally to all, and I'm proud to be a part of it.
Our thanks to Belleville West for being here this afternoon, the students from Cleveland Junior ROTC program and Central Visual and Performing Arts. To the group who joined us interactively from Verona, New York, thank you guys for being here. Give yourselves a big round of applause. It's been an excellent conversation. I'm glad I had the privilege and the opportunity to moderate with the panel here. Next month, we're going to be doing a very different thing with HEC-TV Live as we begin our first series called Explore, which is targeted to students in grades 3 through 6. So it'll be a little bit different, but we look forward to that conversation and another Constitution Day program next year, same date. Bye, everybody.